Now, Anita has had an interesting career. She graduated as a BA and LLB in 2000, I beg your pardon, sometime prior to 2003. She was admitted to practice in April of that year, came to the bar in November of 2003. In 2005, she took up a position with the Legal Services Commission and as a practice court coordinator and deputy pathonetry with the Supreme Court of Victoria. And during that time she experienced a wide range of civil procedures, including of course in the Part 4 and probate jurisdictions, which are heavily dependent upon procedure within the Supreme Court, particularly what we used to call the Master's Office and the Pathonetry's Office. So since that time she acquired quite a new area of expertise and returned to the bar in March 2009 in order to implement that new area of expertise. Anita has prepared a paper which addresses the same general topic as this morning's breakfast briefing as Jeremy, but tackles it from quite different perspectives, in particular in relation to the new jurisdiction of associate judges in Part 4s, and she gives examples of cases heard by associate judges and other matters relevant to the experience she acquired when she was with the court. I'd ask you to give a round of introduction to Anita.
Good morning, everybody. I'm just a bit thrown there because I thought we were going to have a break, so excuse me.
Time is sort of against us in a sense.
Sure, that's fine. Look, what I'm going to do today is just look at two recent cases which are at the end of the paper, which which weren't heard by associate judges, but by judges. But the first part of the paper concerns the referral of Part 4 matters to associate judges, as Tony's indicated. The Office of Master was replaced by that of Associate Judge in amendments to the rules which commenced in December 2008. And it seems that the most recent practice is to refer those matters to associate judges as a matter of course, and that practice is likely to become more frequent. I'm only aware of 2 or 3 cases which have been determined by associate judges, but only one in which judgment's been handed down. So I thought I'd look at that in some detail, provide some factual context to see whether we can really draw anything from Her Honour's decision that might guide us in the running of our cases. So the matter was called Sellers and Scrivener, and I apologise to Andrea in advance because it was actually her case, so she probably knows a lot more about it than I do. It was a case heard by Associate Justice Daly in May of this year and concerned in some ways a slightly less orthodox domestic relationship compared with the Forsyth and Sinclair matter. The deceased, Ronald Scrivener, made his last will shortly after being diagnosed with pancreatic cancer. He died at the age of 76 and left behind a domestic partner, Patricia. I'm going to refer to everybody by their first names after this, and 2 adult children, Andrew and Vicky Scrivener, who were the defendants. There's some suggestion, I think, on the basis of the facts that Ron didn't want to make any provision for Pat at all, really. And the will initially provided for Pat to reside in Ron's home, where they had lived together, for a period of 6 months after his death, and providing she paid the relevant rates and so on. However, that clause had been deleted and a handwritten clause replacing it, allowing her to live in the home for as long as she so desires. Slightly better, but still perhaps a bit unsatisfactory. The will also provided for a legacy of $100,000 to Pat, and specifically noted that the consideration had been given to an anticipated Part 4 claim, and this was the provision that the testator felt was appropriate. The issue really for Pat was that the house that they lived in Templestowe, whilst not quite falling down around her ears, wasn't in very good repair, and if the $100,000 was all she had to live on, she hadn't been working at that stage for a couple of years, then it wasn't going to take long to go through that money to repair the house, and that would leave her with really effectively not very much to live on. So Pat brought a Part 4 application claiming that the will hadn't made adequate provision for her, having regard to the nature of the relationship with Ron and her circumstances at the time of his death. The defendants argued, contrary to that, that granting Pat the right of residency in the Templestowe home for as long as she wished and providing the legacy of $100,000 more than adequately discharged any obligation owed. At the time of the hearing, Pat was 67, so there's a bit of an age gap between them, but not very much. And perhaps unusually for a woman of her age, she'd been in almost full-time employment since the age of 17. After her marriage ended in about 96, she'd received only about $1,500 because her husband had significant business debts, and she had to move to a rented unit to raise her sons. In about 1999, she resigned from her job, citing stress, and relied on Centrelink benefits and a drawdown of her superannuation funds to keep herself and her sons going. In January or February of 2000, she met Ron, and in November of 2000, she again obtained employment. So it wasn't as though in meeting Ron, she intended to stop working. Ron was born in 1943 and was a bookmaker. His marriage to his wife Robin ended in 1999 with her death, and prior to that, about 15 or 17 years before that, Robin's father had died and had left quite a reasonable inheritance to her in the form of property and shares. When she died, her estate passed straight to Ron, and neither of the children really received any significant benefit from her estate. And that was a fact that came to be relevant in the judgment. As I said, Pat and Ron met sometime in January or February of 2000, and by April of that year, the relationship had become intimate and a regular routine was established. They spent weekends together, they went to the movies, visited friends, went on country drives and all those things they do. We do, I suppose. They kept in touch by phone each day, dined out 3 or 4 times a week, and went on holiday in the winter of 2000. Pat introduced Ron to her children very early on in the relationship, and again, it's a little bit telling that Ron was less forthcoming with his own children and only informed them about Pat in March of 2002. There's some suggestion that, in fact, he only introduced them at that time because Pat had been seen or neighbours had conveyed this information to the children. I suppose it's understandable in the sense that his wife had died and the kids might have been a little sensitive about it, but in any event, that's what happened. In late 2003, Ron invited Pat to live with him in his Essendon home. And she agreed to move in with him, but had always been around the Templestowe-Doncaster area and said she really preferred that area. Ron agreed with that and sold his Essendon property. And they initially moved into a rental property in March of 2004 around Templestowe before purchasing the house in which they lived at the time of Ron's death in September. So for all intents and purposes, they were in a traditional domestic relationship, save only that they weren't married. The division of tasks was along the traditional gender lines. Ron paid for the bills, and even though Pat was working full-time and Ron wasn't, she did the housework. Pat also took charge of the couple's social life. Ron seems to have been a fairly private sort of fellow, and in Pat running the social side of their relationship, his circle of friends increased. In January of 2007, Ron's health started to decline and he felt unable to continue driving. And in February, for unrelated reasons, Pat stopped work. She was retrenched and couldn't find another job, so she took over the responsibility of driving Ron to doctor's appointments and social occasions. In January of 2008, he was diagnosed with pancreatic cancer, and from that time to his death in April, he spent only 3 weeks at home. During that time, Pat assisted Ron with his personal care, administering medication, showering and toileting, as well as running errands and doing shopping. And in hospital, she visited every day. So it was a very intimate relationship in that sense. The financial relationship between the two was also covered by Her Honour's judgment. And at the time Ron met Pat, he was semi-retired, although he maintained his bookmaking operations at Caulfield Racecourse until about 2007. And none of the parties had a clear idea of what his financial circumstances really were, but it was apparent from the evidence that he was comfortable and able to live off his the income and capital of his cash without drawing any government benefits, and to assist Pat and also his adult children. Pat, on the other hand, had very little to show for her long years of work. After she finished working in February of 2007, she redeemed her superannuation benefits. She considered applying for the pension, but because she lived with Ron, it was necessary, or would have been necessary, for him to provide a statement of assets to Centrelink in order to assess her entitlement, and he wasn't prepared to do that. So instead he offered to pay an allowance to Pat of $500 per month for her personal expenses. He also paid out some debts for her, a credit card debt, and bought her a car. He also paid for the dinners out, their holidays, and all of their joint social costs. In terms of the defendants, Andrew and Vicky were both tertiary educated, and there's very little evidence of their respective incomes provided at trial, but the court inferred that they both enjoyed a pretty comfortable middle-class existence. Ron had provided to Andrew and Vicky some modest financial assistance over the years, and as I mentioned, neither had received anything of significance from their mother upon her death. They visited Ron as children would in hospital, and it was apparently at their request that the will was altered so as to make some provision for Pat. And perhaps understandably, the relationship, which up until then had been cordial, changed somewhat when Pat made a claim upon the estate. Counsel for Pat argued that the right of residence in the Templestowe property and the legacy of $100,000 was inadequate, having regard really to the quality of the relationship between Pat and Ron, the absence of competing financial claims from Andrew and Vicky, and he submitted that in the context of a testator's responsibility to his widow, adequate provision necessitates the provision of a secure roof over the head and a nest egg, which is the well-known expression of what's appropriate for a widow. And although Pat and Ron weren't married, he said there's no distinction in the Act between legally married widows and de facto widows, and the principles applicable were similar. The right of residence, he didn't provide Pat with any flexibility in relation to her needs as she got older, so she wouldn't be able to sell the property and purchase alternative accommodation or access the equity to pay for a hostel or nursing home. And he said the $100,000 was an inadequate cash legacy, having regard to the fact that Pat really had no money and was likely to be completely reliant on the pension. Andrew and Vicky's counsel, I say Andrew and Vicky, but it's really Vicky's counsel because sometime just prior to the hearing, Andrew became self-represented, and although it's not possible to say with any certainty, in my view, it may have had an impact. The fact that Andrew was self-represented may have had an impact upon the decision because he was quite emotional in court on occasions, and he didn't speak with the objective language that counsel might use, especially in these. So he made claims that making particular orders would be morally wrong, and quite emotive language. Anyhow, so it's really Vicky's counsel. She submitted that that there are differences between legally married widows and de facto widows, and there's an excerpt from a case of Justice Ip in Bladwell and Davis there, where oh, sorry, I've just misled you there. The excerpt from Bladwell and Davis is in relation to the claim of a widow as against adult children, and he makes the point that a widow's hardly likely to be in a position to improve her financial circumstances, and where the other parties are materially younger and are able to do so, then that gives really the claim of the widow primacy. So then moving to Vicky's counsel, she claimed that that a de facto partner is not equivalent to a partner in marriage, except where it's an exceptionally long relationship or where the parties might have raised children together. Neither was the case here. She also submitted that any obligation of Ron's toward Pat had to be considered in the light of his obligation to his children, especially in circumstances where much of Ron's estate had been derived from that of his wife, and that ultimately appeared to be an important consideration for Her Honour. So in the decision, Her Honour set out each of the matters requiring consideration under section 91, subsection 4, and it's quite a helpful judgment in the way it's been set out, and perhaps that's a consequence of Her Honour beginning to hear these cases. It's quite well set out. She set out the requirements, the considerations, and then each of the party submissions, and then what she'd found in relation to those. What she said was really the critical factor was Pat's circumstances, financial circumstances at the time of Ron's death. Notwithstanding that there'd been a degree of financial independence through some part of the relationship, by the time of Ron's death, she'd become almost completely financially dependent on him, and Ron had assumed responsibility to maintain her. I also thought, as I've alluded to, that Her Honour's view was noteworthy, Her Honour's view that Ron's responsibility to the children was particularly, or had a particular responsibility because of the substantial part of his estate which had been derived from Robin. What Her Honour said was that if the court ordered provision in Pat's favour of a substantial proportion of Ron's estate, would require Andrew and Vicky to postpone their entitlement to their mother's assets for a second time, first to support their father and then to support Pat. And would also leave them dependent on Pat's good graces if she obtained provision absolutely and then decided to will her assets to her own children, and would force them to contemplate themselves bringing a Part 4 claim, and that was to be avoided. Ultimately, what Her Honour did was order that further provision should be made for Pat, but she sought to avoid the problems outlined, and she revoked. So what she did was she revoked the right of residency in the Templestowe property, and established a trust for Pat in the sum of $420,000, which was for the purposes of a unit in the area being purchased. So presumably along the lines of somewhere newish that isn't going to require a lot of repairs. And Pat would have all the rights and obligations of a tenant in accordance with the Settled Land Act. The legacy was amended to substitute the amount of $198,000 for $100,000. So on the face of it, it's quite a conservative judgment, but on the other hand, it's a little surprising that in spite of the lack of authority for the proposition that the relevance of the source of the assets, or that the source of the assets is relevant, Her Honour seemed to give that issue some weight. But as I mentioned, Andrew appeared self-represented and was at times highly emotional, and he expressed quite a lot of indignation really at the idea that any provision should be made at all. His feelings towards Pat and his relationship with her had clearly deteriorated by the time of the trial, and yet the establishment of a trust will require an ongoing relationship between them. On the other hand, the judgment allows Pat some flexibility, to obtain a residence in good repair, and doesn't or overcomes the problem of making provision for her absolutely, and avoids the problem of Andrew and Vicky potentially having to make a claim on her estate. So whether we can take anything from that or not, I think it's more likely to be, or it's likely to become a common occurrence for these matters to be referred to Associate Justice Daly in particular, and so watch this space. I suppose it's worth having a careful look at the judgments which come down. Just quickly, two other recent and noteworthy cases. One is a decision of Justice Vickery, it's Robertson and Koska, which concerned an application by stepchildren of the deceased, but they were stepchildren who weren't raised as part of the family. And the other one that Jeremy mentioned as well was Unger and Sanchez, which was a decision of Justice Kay, where the plaintiff was a friend and neighbour of the deceased, but that was the extent of the relationship. In Robertson and Koska, The application was brought by 3 stepchildren of the deceased. There was a 4th, but a claim made by that person had already been settled earlier, and that 4th, it's worth saying, was a child of the not of the relationship, but who did grow up as part of the family, which is perhaps what distinguishes them. In 1957, the deceased, Frank, married Helena, who had 4 children from a previous marriage, then aged a daughter of 8, twins of 7 years old, and another daughter aged about 6. The two had no children between them, and Frank had no children from any relationship. When Helena died in 2001, each of the children received about $5,000, and that was it. Frank appointed his cousin-in-law Zelko, the executor of his estate, and apart from 2 minor legacies, left his entire estate to him. So it's, you can infer from that that whatever Helena had went to Frank, and he made no provision for the stepchildren. The circumstances in relation to the children were perhaps unusual by today's standards, but given the absence of social security benefits or anything of that kind in the early 50s, perhaps a bit more understandable. Helena left her first husband, Stanislaw, and the children in late 51 or 52. There were a couple of short-lived reconciliations between the couple, and during the last one, they resolved to stay together, but Stan, as I'll refer to him, left home to pursue seasonal work interstate. While he was away, in 55, Helena left Irene in one orphanage, that was the eldest daughter, and the twins, John and Lewis, in another, and then moved interstate with the youngest child. A couple of years later, in 57, Helena married Frank, and between 55 and 58, the children remained in the orphanages before being fostered out to different families. Irene came out of the orphanage in about 61, out of the foster arrangement in 61, and 63 for John and Lewis. So it wasn't the case that once married they got the kids out and raised them all. The couple just continued to raise Marianne, the youngest child. In about 1961, Irene found or somehow obtained Helena's address from her aunt, and from thereafter there was regular contact between each of the children and the parents. They stayed for visits, and on one occasion the twins, John and Lewis, lived with their mother and stepfather for about 8 months. The visits continued as each of the plaintiffs married, and genuine and loving relationships were formed between Helena and Frank and the children of the plaintiffs. And considering the entitlements of stepchildren, Justice Vickery considered that it was relevant to look at the extent to which the children were raised as part of the family, as distinct from those who may have only been members of the family for a brief period and with limited dependence. And he referred to an unreported New South Wales decision, which is referenced in the paper. He said further that if children of a first marriage had stood aside in order that their children, that their father might make provision for a widow, then the amount left by the father to the widow may be relevant to the question whether upon her death she's responsible to provide for those children. That's the, I think, usual position, and by comparison, the Sellers and Scrivener matter seem to want to slightly alter that analysis. So the usual thing is if the step-parent is the deceased, and if they've not made a provision for the children of their partner, then the source of their assets becomes relevant to whether or not they've got a responsibility. What Associate Justice Daly did was said that the father, the actual father of the children, had a particular responsibility to his children because of where the estate assets came from. So I think that's sort of a little bit of a twisting of what the general principle is. But in any case, in this matter, the estate was valued at about $480,000. His Honour gave some weight to the value of the estate, the means of each of the plaintiffs, and the fact that there was no other remaining family member or other person to whom the testator owed any moral duty, and ordered provision in the sum of $55,000 in respect of each of the plaintiffs. obviously the earlier claim was settled, so we don't know what the sum was in that case, but I think we can infer that it was somewhat less than that and reflected the degree of independence of each of the plaintiffs. Unger and Sanchez, as Jeremy mentioned, is under appeal, so when the decision comes down I'll try and let you know what the outcome was, because it's an interesting case. Kathleen Unger, who's the plaintiff, was not related to the deceased in any way. The deceased was called Julie, but was a neighbour and friend who acted as the carer of Julie and Stan in their later years. Julie, the deceased, was born in Spain in 1934 and migrated to Australia in 1962. She married Stan in 1967 and they purchased a home in Caulfield, and they had no children. The defendant was a sister of the deceased who lived in Spain. Now, in the will, the deceased had directed the defendant to distribute her residuary estate among brothers, sisters, nieces, nephews, as she, in her absolute discretion, considered appropriate. For the purposes of the claim, the estate was worth about $1.5 million. It was the plaintiff's case that during Stan and Julie's last years, she adopted the role of carer and guardian to both of them, and that during that period she formed a close personal relationship with them, so that they regarded her as their adopted daughter. And the plaintiff gave evidence that, in fact, Julie had asked Kathleen if she could regard her as a daughter, notwithstanding that there was only 12 years between them. The defendant countered that as she was the youngest daughter, it had been her role to remain at home in order to look after their mother, and that it was a result of that obligation that she'd never married nor earned any money on her own account. Julie, she said, could never have left Spain and made a new life in Australia if she hadn't assumed that responsibility. Now, because the delegation of the deceased's testamentary disposition wasn't permitted, effectively the defendant was the sole beneficiary of the estate. In her affidavit, she deposed that she was 75 years old, suffered from some heart problems, but was otherwise in reasonable health. She lived in a simple rented apartment without a shower or running hot water, and used the rent from an apartment earlier purchased by the deceased to supplement her pension of about $500 a month. She also set out the financial circumstances of the other members of the family to who might be beneficiaries if she exercised that discretion, and they were all of modest means and assets. Now, as we're all familiar, the relevant issues for consideration are whether the deceased had a responsibility to make provision, whether the deceased had failed to make adequate provision, and if so, the amount of any provision that should be ordered. Justice Kay likened the relationship between the plaintiff and the deceased to that of parent and child, again notwithstanding that the testator was only 12 years older than the plaintiff. He found that the deceased had reposed, and her husband had reposed, almost complete trust in the plaintiff in her last 7 years of life, including entrusting her with powers of attorney and appointing her as executrix of her will in the event she predeceased her husband. And the plaintiff had assumed very significant and onerous responsibilities on behalf of Julie and Stan. At one stage, they had to go into residential accommodation, and the plaintiff cared for and maintained the home. She made decisions in respect of their accommodation. There were some issues at the nursing home in which they were residing, and the plaintiff really agitated in respect of those and advocated on their behalf. She visited them daily, took them for outings, attended to their needs, and really became their primary source of care and comfort. In His Honour's opinion, the kind of devotion given was at least equal to, if not well in excess of, the dedication that might be expected of an adult child to an ailing and ageing parent. By her actions, he said, the plaintiff adopted the deceased and her husband as they adopted her. He said those findings were relevant to, but not determinative of, the question whether the deceased had a responsibility to provide for the proper maintenance and support. They were also relevant to the question of the deserts of the plaintiff, which in section 91, subsection 4, paragraph K, is expressed as any contribution made by the applicant to the welfare of the deceased or the family of the deceased. His Honour considered that although the care and attention given was for a limited period only, it occurred at a time when Julie was particularly in need of help and had no one else on whom to rely. The fact that the plaintiff wasn't a child reciprocating care given nor was she motivated by ties of blood or family, only made her conduct more worthy of merit in His Honour's opinion. And those considerations, he said, would have been taken into account by a wise and just testator. That relationship, in His Honour's view, constituted a very strong prima facie basis for evidence of a duty to make provision, but it was necessary to consider the question in the light of all the relevant circumstances with the matters in E to P of section 91.4. In that context, the relevant factors included the existence of any competing claims, the size and nature of the estate, and the financial resources and means of the plaintiff. And it's that last point which is really I think the source of the appeal, and B, the contentious point in the case. There was no argument really with the argument that the deceased had a responsibility to provide for a sister in the circumstances. The contentious point was concerning the financial resources of the plaintiff, which comprised a half interest in her home in Caulfield, which was valued at about $500,000, interests in 2 investment properties, an accrued superannuation entitlement, shares in a flooring business operated by herself and her husband, and cash, altogether worth about $1 million. However, the way in which her finances were structured, which was part of a succession plan in favour of her son, meant she had a very low income of only a little over $10,000 per annum. His Honour rejected the defendant's submission that the plaintiff was wealthy and said, there were authorities supporting the proposition that a claim need not be indigent or in difficult financial circumstances to qualify for provision. And he said the plaintiff's financial position was not so great as to negate the obligation of the testator to provide for her, that obligation deriving from the plaintiff's close bond and the plaintiff's selfless service to the testator in the later years of her life. His Honour considered it the moral duty of the testator to make some provision in the form of a legacy in order to provide a measure of liquidity to her, and ordered provision in the sum of $200,000. Notwithstanding His Honour's lengthy explanation that he regarded the circumstances of this case to be quite exceptional and the deserts of the plaintiff extraordinarily strong, the defendant has appealed, and of course the judgment then therefore needs to be treated with caution. And so watch this space, and as I said, I'll make you all aware of what that decision is when it comes down.
Thank you, Anita. If you could show your appreciation in the usual way. So you've there heard a pretty thorough exposition of all the relevant Part 4 cases that have occurred over the last 12 months or so. Now, we are having questions. Yes, one question there, sir.
In now taking instructions for a will based on Forsyth and Sinclair...
Is that David Hughes?
It is.
Through the dark? Yes, yeah.
What questions do we have to put to your testator to ascertain their relationship to overcome a claim against that estate?
Jeremy?
Well, beyond the family and the immediate family and the sorts of relationships which one would generally anticipate might give rise to a claim, the thing about the relationship in Forsyth and Sinclair and the thing about the relationship in Unger and Sanchez is that they were quite remarkable or unusual relationships, but they were relationships which had in common an enormous degree of commitment and closeness between the parties and devotion. And they're the sort of relationship which, with, I suppose, a degree of probing, is going to come to the fore fairly quickly. In Forsyth, a life partner who, doesn't live under the same roof, but they're sharing their lives to a considerable extent, and perhaps that's something that needs to be explored. Okay, you have a partner, you don't live with your partner, but tell me about the relationship. Unger and Sanchez, there's someone who looks after you. Do you pay this person? Is this person a relation? What exactly does she do above and beyond the call of duty? But I think it's a good question. I think it means you need to probe beyond the standard, conventional, predictable relationships, but look for the hallmarks of dedication, devotion and commitment.
And I'm sure you'll do that, David, with your usual sensitivity. In further explication of that answer, I don't think you have to do a great deal more than a prudent solicitor would currently do. I think the big change occurred after the 1998 Wills Act amendments, when you went from husband, wife, son and daughter to claimants from all areas of life, that is to say those to whom the deceased had an obligation. And I think your questioning should just be directed fairly discreetly to the deceased as to those matters that might come to your mind, which would give rise to an answer from the will maker that yes, I did have a housekeeper with whom I had a relationship, or I did have a gardener who I was particularly close to and used to give annual gifts to, or I did have a dog that was particularly close to me in my elderly years. So, you know, there's no great adjustment. You just got to be a bit more probing in the light of what you know to be the guidelines established by the courts. Further questions? Yes.
In the newspaper, there's a reference to Associate Justice Daly's reliance on the source of the estate assets and to a darkened authority as to the relevance of those. The only authority I can think of, though, is those tracing cases involving stepchildren and claims on their step-parents' estate. And I think there's some sort of connection there.
Yes, I think what you're alluding to is what I alluded to, in that in the Robertson-Cosca one, Justice Vickery was talking about the claims where children made a claim upon the estate of the step-parent. So there's some analogy there, that's true, but where the children make a claim upon the estate of the step-parent, that question is relevant to whether or not the step-parent had or the source of the assets is relevant to the question whether the step-parent had a responsibility to those step-children. And the Sellers and Scrivener one was a little bit different, because Her Honour said the claim, first of all, was by the children upon their own father's estate, and she said, I suppose by analogy, that he had a particular responsibility toward them because the estate assets had come from his wife, rather. And as I understand it, there's not really authority for that proposition. So it's a by analogy thing, which you might say is brave, given that associate judges are just beginning to hear those cases, because in other respects it's pretty conservative.
Thanks for that, Anita. Any further questions? Yes.
Anita, again, do you know what the cost order was in Robertson?
I don't, I must say. I thought you were going to ask me about Sellers and Scrivener, and I was leaping up. That was the.
I take it these
one.
cases are reported, are they, before the Associate Justice? Oh,
Yeah.
Certainly Robertson-Cosca was vicarage, eh?
Yeah.
But are the Associate Justice cases reported?
Well, they're certainly on Ostley.
Yeah, Ostley.
Yeah.
Okay.
No, I don't know what the costs decision was in Robertson. Sorry.
Yes, Jeff.
Do we think these claims may be limited to natural persons, or is it possible that there could be claims made by a corporation, as for example, charity, where the testator had been in the habit of giving over a long period of time to a charity, so that that charity may have built up some dependence upon the testator. As for example, somebody being in the habit of making donations to the Lost Dogs Home over a period of time.
Have you got the Act in front of you?
Only what's here.
I think it refers to person, doesn't it?
Well, it refers to age, but that's only one consideration. I just wondered whether it might be, whether it would be.
I just haven't got the Act, but I thought it referred to claimant or person, and it has to be a natural person, I think.
Well, that was my question.
That's my view. I may stand to be corrected, and any judge of the court who decides otherwise is a very brave person, and I emphasise the word person. Bruno.
The way the decisions are going, looking forward, the situation where persons in a second relationship haven't moved in, I'm sometimes asked by children who are concerned about relationships between their widowed father or widowed mother. Are the courts now really broadening the situation, saying that even where they're not living together and maybe not sharing bank accounts and finances, it really is going in that direction, that there is a lot of danger signs for children?
Well, that's Forsyth and Sinclair. They weren't living together, never did live together, hardly mixed any assets, but had a relationship over many years, which the children, i.e. the child in your situation, was fearful of, but the children had no evidence because they didn't see this woman much. Hardly ever knew of her, never took phone calls, and yet the court has applied, the important principle of that case is the court applied the moral obligation to a traditional non-de facto situation. So yeah, there are warning signs.
It seems a very dangerous way forward. Do you believe that's going to be followed?
I do. But it's a question whether it's followed. Each case depends on its facts. As I referred to them earlier there, it's really equity running down this area. And the principle will be followed, but it will be applied differently according to the facts. The facts in that case were unusual, as they were in Justice Kay's judgment in Unger and Sanchez. So you've got to, in that situation, rely on the wisdom, common sense and integrity of the courts, who will apply that.
Any recommendations for children in the Sinclair Forsyth situation in regards to advising the widowed parents going forward?
Difficult. Keep tabs on your father's de facto partner. Get a private investigator. Get your father or mother to put a particular provision in a will, or write a letter annexed to a will detailing the nature of the relationship, that sort of thing. But there are limits to what you can do. I think we'll call a halt to coffees. That shows you my mindset. A halt to questions there, and there's a quarter of an hour left for mingling and coffee, and I'd like you to put your hands together to thank our two guest speakers today.